Good afternoon, everyone, and welcome to our CCOVI lecture for today. I'm very pleased to introduce our speaker. I should introduce myself. Sorry, I always forget to do that. I'm Debbie Ingalls, the director of the Cool Climate Enology and Viticulture Institute here at Brock University. And today we have with us Alexandra Mayeski. Alexandra is a CCOVI professional affiliate, but she's also a partner at Mayeski Mathers LLP law firm. So Alexandra has an administrative law and litigation background, and her firm, Mayeski Mathers, has offices in both Toronto as well as Prince Edward County. She has focused her practice on issues facing the wine industry, including regulatory matters involving licensing, sales, distribution, both domestic and foreign, as well as marketing and advertising. So we're very pleased that she'll be with us today to speak about some of the current legal issues facing the Ontario wine industry and some of the changes that are coming about. There's some great case samples that she's going to share with us today to sort of walk us through and teach us about these changes. So thank you very much.
Thank you. Well, thank you for having me. It's been a couple of years since I've been here. The last time I was here, I worked at a national Bay Street firm, and I was a co-founder with my colleague and friend Martha Harrison, an international trade lawyer of our wine law group. At the time, we had a place in Prince Edward County that we went to on weekends, and I since left the Bay Street firm for better quality of life. I made the getaway the everyday, and my 3-hour-a-day commute from Burlington to Toronto is now 3 minutes. And like Debbie said, you know, while I still maintain an office in Toronto, the head office is in beautiful Prince Edward County. So what Debbie didn't mention, I have a personal stake in all of this. So we have a very small test plot vineyard on our property. But that's kind of my husband's department. It's an excuse for him to buy a tractor and putter around. So I focus on the legal aspects of it. I hope I get this technology right. I've got two microphones and PowerPoints, which I always seem to make mistakes on. So hopefully I can get all this right. So I just thought I'd touch briefly on what I talked about last time. When I was here last time, we spoke about the legal barriers to market access for Canadian wine, and most of what we talked about was trade-based. We talked about the trade agreements between the US and Canada and the consequences for Canadian wine. We talked about some of the archaic Canadian distribution laws, which are always a topic of conversation, and that was pre-Bill C-311, which I'm going to talk to you about today. We also talked about the issue of dumping, and for those of you who don't know what dumping is the introduction of a product into another country at less than its normal value. We talked about the argument that there may be some dumping going on here in Canada by other countries, and how these issues were investigated by the Canadian Border Services Agency in the Canadian International Trade Tribunal, and how those matters are finally adjudicated. And finally, we looked at some barriers to market access at the municipal level, and I talked to you a bit about a particular case out of Prince Edward County, now my neck of the woods, where the county was attempting to arguably exceed its jurisdiction through its zoning bylaws. And in that case, the county was mandating the amount of fruit content a winery could use in its wine in order for it to be considered a farm winery. But today, I'll just give you a brief overview of what we're going to talk about today, and I'll mention something that all lawyers do, is to remind everybody that what I'm going to talk about is not legal advice. It's information, and that, you know, lawyers always encourage you to seek your own legal advice. But I just thought I'd look today at the first of all, the legal landscape in which the wine industry operates. And it won't be in any great detail, but we'll give you a flavor of the types of provincial laws that are currently in place. Then we will talk about a recent case which encompasses a myriad of legal issues for the wine industry, and that case involves the LCBO, a wine club, and the Information and Privacy Commissioner of Ontario. It encompasses privacy issues, regulatory issues, trade issues, constitutional issues, administrative law issues, appeal issues. So it's a feast of fascinating legal issues for lawyers. So we'll spend some time looking at that case. And we can't talk about the legal issues facing the wine industry without looking at some of the distribution laws. And there have been some positive changes since the last time I was here. And finally, I'll talk about the change in people's attitude towards Canadian wine and why I think this is a very positive development. And while it's not strictly legal, it's because of those positive changes that we do see change on the legal front. So starting with the regulatory landscape, and as I said before, I don't propose to go through all the laws that affect wineries, but I thought it might be useful to give you an idea of some of the players, which many of you probably already know, that wineries need to deal with as wine producers. And the overriding goal of these regulatory bodies is the protection of the industry and the protection of public at large. And they are the AGCO, the Alcohol and Gaming Commission of Ontario, the LCBO, the Liquor Control Board of Ontario, and VQA Ontario, the Vintners Quality Alliance Ontario. So starting with the AGCO, the AGCO is responsible for administering the Liquor License Act that covers most aspects of Ontario's beverage alcohol laws. The Liquor License Act provides the regulatory requirements for the responsible sale and service of beverage alcohol in Ontario. It's the LLA, which I'll refer to it as, and its regulations provide the registrar of the AGCO with the authority for regulating and licensing a number of things such as liquor sales licenses, ferment on-premise facility licenses, liquor delivery service, manufacturer's licenses, and manufacturer's representative licenses like wine agents. And through the investigation and inspection branch of the AGCO, the AGCO works independently and in partnership with local police services to conduct LLA inspections and investigations on licensed premises, such as bars, to ensure compliance with the LLA and investigate any breaches or complaints relating to the LLA. And the LCBO, as many of you know, it's a Crown agency that reports to the Minister of Finance. It's the corporation is established to sell liquor, beer, and wine through a chain of retail stores. It operates over 600 retail stores, I believe, and it is the sole importer of liquor into Ontario and has broad powers under the Liquor Control Act. These powers include controlling the sale, transportation, and delivery of liquor, authorizing Ontario Wines to sell their wine in stores owned by the winery, controlling and supervising the marketing methods and procedures of wineries, and controlling and keeping of wine in and delivery of wine from warehouses. So the LCBO has inspectors who conduct inspections to determine whether there's compliance with the Liquor Licensing Act and the Liquor Control Act and the regulations to those acts. The actual inspectors of the LCBO have broad powers and may enter into a building at which records relating to the sale, service, manufacture, or storage of wine are kept or are required to be kept. They can request that these records be produced for inspection or audit, and license holders such as wineries are also required to answer any inquiries made by the inspector that are relevant to the inspection. VQA Ontario is VQA's wine authority. It is the regulatory agency that is responsible for maintaining the integrity of the local wine appellations and enforcing winemaking and labeling standards. It's not a marketing agency and doesn't represent the wine industry, but rather its functions are primarily on wine tasting, audits, inspections, and compliance. So for example, VQA requires the wineries to demonstrate the origin of all grapes used in VQA wine. One of the current issues that for Ontario wine is that the VQA Act it might be getting a little bit outdated. There is Regulation 406 of the VQA Act, which sets out authorized grape varietals. However, some wineries are expanding their grape use to new hybrid grapes. For instance, Frontenac, I understand, is a new grape which is used, which doesn't currently qualify for the VQA designation. I can think of one in my neck of the woods. Carlo Estates has a great white port that is made from the Frontenac grape, and so that doesn't have the VQA designation. So it may be an indication that we need some progress in that area, some changes in those laws. So even though these grapes are 100% Ontario grown, they're actually taxed at a higher rate. So the VQA designation also doesn't take into consideration wines that have fruit wines, for example, is another area where they don't consider them. So again, there might be some need for change on that front. So like the LCBO, the VQA conducts winery and retail store audits. They examine winery records and inventory to determine whether VQA regulations are met and whether all volumes of VQA wines are substantiated with respect to origin and other requirements. They look at information about wines offered for sale, including the use of VQA terms to determine whether the wine is in fact approved and complies with labeling requirements under the regulations. A cautionary tale. So fortunately, there haven't been a lot of reported cases involving wineries being offside the liquor rules. That's good news. Many of these matters don't go all the way to a hearing, and if there are issues that arise during the course of an audit, it's usually the case that those issues can be dealt with directly with the regulatory agency. That said, I thought I would share with you this cautionary tale that arose out of the decision of the board of the AGCO back in 2008. And while it is a public record, I'm not going to disclose the name of the winery. It doesn't serve our purposes. It's a cautionary tale, and it could happen to any winery. So I'll just give you a bit of the background. So in this case, a winery appealed the decision of the VQA to revoke its membership under the VQA Act before the board of the AGCO. And it all started when the winery submitted samples of its Riesling Reserve to the VQA for approval in April 2007. And I mention the date only because it's important in terms of the sequence of events. So also by way of background, this particular winery's Riesling Reserve had been approved by the VQA 3 years prior, so it was just anticipated that it would be approved again. And normally, I understand the regular turnaround rate for VQA to approve is approximately 3 weeks. And in this case, after about 2 months in June, the winery called VQA, hadn't heard anything, to find out what was going on. And the winery's evidence, according to the decision, was that it received verbal approval from the VQA regarding the Riesling Reserve, but was told that the paperwork was delayed due to computer problems. So relying on this verbal approval, the winery stocked the shelves with the Riesling, with the VQA labels on the shelves. And this is mid-June, during a VQA audit that same month, so June 2007, the winery was told that the Riesling Reserve had in fact not been approved, and the auditor requested that it be taken off the shelves, which the winery did. The winery complied. So then the winery calls up the VQA, who at the time denied that any verbal approval had been given, but cited that because the winery was delinquent with its fees, that was the reason for the non-approval. So the winery looked into its records, looked into the delinquent fees issue, sent a check, and assumed, wrongly, that once the money was received, approval would be forthcoming, but not so. So that's June. In July, the winery was observed again by the VQA as displaying this mislabeled Riesling. And at that time, the VQA warned the winery about the violation with respect to its labels, and that further action might be taken under the VQA Act. The auditors came once again in July, and this time one of them asked the staff if he could buy some of their Riesling Reserve, which wasn't on the shelves, but the employee went back to fetch the wine, brought it out, and alas, it had the VQA label on it. August 1st comes. VQA advises the winery that the Riesling Reserve would not be approved because of the history of mislabeling. The winery argued that it was a result of employee error, that the mislabeling happened. Completely understandable, this can happen. But unfortunately, the winery was subsequently charged and was found guilty of 2 charges with a $2,500 levy for each guilty offense. That was done in February 2008. Fast forward June 2008, a few months later, VQA once again observes 3 bottles of the same Riesling with the VQA label for sale at the winery. Again, employee error. So relying on the VQA bylaws, the VQA argued that it had no choice but to revoke the winery's membership for a period of 12 months because the winery had committed these 2 offenses. And the winery appealed that decision and argued that the offenses were mistakes, that it would suffer financial hardship if it fought the charges at the time and therefore agreed to the guilty plea and just paid the fees. It also argued that the revocation of its membership for a period of 12 months would impose significant financial hardship on this small winery, understandably so. Because if their products don't have this VQA designation, they argued it'd be much more difficult for them to sell their products to restaurants, for example. So under VQA's bylaws, membership must be revoked if a winery member has been convicted under the VQA Act and remains in contravention. So it's a mandatory bylaw. The VQA has no discretion to do otherwise. And in this case, because the winery had violated the VQA Act, even after being convicted in February 2008, the board of the AGCO upheld the membership revocation of the VQA. So I explained this cautionary story again to say that it could happen to any winery. It's a demonstration of how heavily regulated this industry is, from labeling to bottling records to tank records, blending records, and that anything offside can have significant consequences to the point where your VQA membership is revoked, in this case, to possibly your license being suspended or revoked. So now for one of the most interesting cases of the year that I was talking about. It combines my 2 loves, wine and privacy law, which is also a part of my practice. I do a lot of work with respect to the Freedom of Information and Protection of Privacy Act, which I will refer to as FIPA. It's known as FIPA. And this case is about a wine club challenging the collection of personal information practices of the LCBO. But it goes much further than that. So why don't we start by setting the stage of the players and the legislation, some of which we've already spoken about. So the LCBO sells approximately $1 million in liquor annually through its private ordering department. And this includes the sale of alcohol to members who order through clubs, like wine clubs. And these wine clubs aren't licensed by the AGCO and have no special status, entitlements, or recognition under the Liquor Control Act or under the Liquor License Act. However, these wine clubs do make special orders on behalf of club members if they register with the LCBO. Once they register, they are subject to the LCBO procedures set out in the business, process, and program guidelines, spirit, beer, or wine clubs. And the procedures in the guidelines are not based on the requirements in either the Liquor Control Act or the Liquor License Act, but have been developed by the LCBO. And the information gathering procedures that we're going to talk about are set out in these guidelines. And under these guidelines, sales can be made to wine clubs as long as the order is accompanied with the list of the members. And this information includes the name and contact information of the members, as well as the details of the products being ordered, and from the customers who are placing the special orders, and this is regardless of whether it's through the club or individually. The LCBO collects this personal information. And just by way of reminder, the legislative framework for the sale of liquor can be found in the Liquor Control Act, which establishes the LCBO's mandate and gives broad authority for liquor sales. Section 5 in particular of the Liquor Control Act prohibits anyone from keeping for sale, offering for sale, or selling liquor, as well as canvassing for, receiving, or soliciting orders for the sale of liquor unless licensed by the AGCO. FIPA. So FIPA is a statute that contains provisions regarding both freedom of information and access to records. It's the purpose of the access provisions are to make governments accountable and more transparent. And the other side of FIPA is the protection of individual privacy. And that's what was an issue in this particular case. The legislation strives to balance individual privacy rights with the need for government to collect personal information. And Section 38 sub 2 of FIPA, which is on the slide, prohibits government institutions, including the LCBO, from collecting personal information except in 3 circumstances. First, if it's expressly authorized by statute. Secondly, if it is used for the purposes of law enforcement. Or thirdly, if it is necessary for the proper administration of an authorized activity. So just by way of background to the case, Order PO 3171, I don't know why they do this, there's no names to these cases, they just put numbers to them. It was a decision of the Information and Privacy Commissioner of Ontario, the IPC, about a year ago, February 27th, 2012. And in that case, a certain wine club registered with the LCBO in 2004 and alleged that it was not required to provide personal information of club members when it submitted its orders from 2004 to 2012. Come 2012, the LCBO refused to process the wine club's orders until it disclosed the personal information of the individual members. And in response, the wine club filed a privacy complaint. The wine club objected to the LCBO collecting the personal information of its club members and argued that the practice violated the members' privacy. The complaint was limited to situations where the orders were placed by the club on behalf of its members and then picked up and distributed by the club to the members. There's also a process by which the club can make the order, but the individual can actually go to the LCBO and pick it up themselves. They provide their personal information and they get their order that way. So that mechanism where the individual goes to the LCBO to pick it up was not an issue. It was only the issue with respect to the club making the order, the club picking it up. So the club took the position that the information being collected was not necessary to complete the customer's order and that members should be afforded the same level of privacy that an LCBO retail customer is afforded when you go buy liquor at the LCBO. The LCBO, however, argued that the collection of personal information was necessary for the proper administration of a lawfully authorized activity, the third point 3 in the prior slide under FIPA. So the LCBO argued that its collection practices were, like I said, necessary for the purpose of administering the wine club program, that it was directly related to its authority to sell and control the sale of liquor in Ontario, and finally to properly manage and administer the board under the Liquor Control Act. The LCBO also argued that the collection of personal information was necessary to process transactions, and in particular to facilitate joint ordering by wine club members in a manner consistent with the requirements for a transaction where goods purchased are to be delivered at a later time. It was necessary to facilitate the recall of products if a defect was discovered. It also enabled audits of the operation of the wine club program, and it's also used to deter fraud such as the illegal resale and stockpiling of liquor. In the result, the IPC held that the LCBO failed to establish that the collection practice was necessary to the proper administration of its spirit, beer, and wine club program. The LCBO practice was not necessary to process transactions and was not more than merely helpful for facilitating recalls and deterring illegal activities. And just by way of interest, I thought I'd read to you what the Privacy Commissioner found. Anne Kavukian is our Privacy Commissioner. It is rare that she actually writes decisions. There are other adjudicators there. So I thought you might find it of interest. She says in her decision near the end, she says, "In my view, the LCBO has not provided my office with much more than anecdotal or hypothetical evidence to support its position that the illegal resale of liquor by wine clubs in this province is so problematic that it necessitates the collection of the personal information of club members who purchase wine through their clubs. Having regard to the other means available to the LCBO to deter and detect fraud, even if this were an issue of great concern, collection is not necessary for this purpose. While I acknowledge that any illegal resale of liquor would result in potential revenue loss to the province, without any evidence that this is actually occurring and on a significant scale, I am unable to find that the collection of personal information relating to spirit, beer, and wine club purchases is necessary for the operation and management of the LCBO's club purchasing program. In summary, I'm not satisfied that the LCBO has established that the collection of personal information of wine club members purchasing wine through its private ordering sales channel is necessary to the proper administration of the lawfully authorized activity. The LCBO has not persuaded me that it is necessary to collect this information to ensure that a transaction is fulfilled, to facilitate the recall of products, enable audits, or to deter fraud. Therefore, with the exception of those circumstances where a club member has arranged to personally pick up his or her order at the LCBO, I find that the LCBO's collection of personal information relating to club orders is not consistent with Section 38 sub 2 of the Act. What is interesting about this decision for a privacy geek like myself is that the Privacy Commissioner invoked her order-making powers in this case, and this is only the second time the IPC has done so since 1987. So in particular, the IPC ordered the LCBO to cease collecting the personal information of spirit, beer, and wine club members when processing purchase orders submitted by these clubs on their behalf, except where the individual intends to pick up the products ordered. It also ordered the LCBO to destroy all personal information collected from club members when processing purchase orders submitted by clubs on their behalf, except where an individual member picks up the products ordered. So then, what happens? So then the LCBO launches a judicial review of the IPC's decision before the divisional court, and the divisional court in Ontario is usually the court where people appeal matters of a administrative tribunal like the IPC. And this is where things get really interesting. because the LCBO argues, among other things, that the LCBO erred in law. These are kind of your standard, typical grounds for an appeal in administrative matters. They erred in law, they acted unreasonably in concluding that the LCBO's collection of personal information was not necessary to the proper administration of a lawfully authorized activity, namely the purchase, importation, and sale of liquor to those members by the LCBO pursuant to the Liquor Control Act and the Importation of Intoxicating Liquors Act. Now, this is the first time that the Importation of Intoxicating Liquors Act is ever mentioned. It is not mentioned in the decision of the IPC, so I don't know if it was considered. I didn't see the background submissions made to the IPC, but it certainly wasn't a consideration. So let's back up a bit, because I want to bring you up to speed as to why this is significant. So the Importation of Intoxicating Liquors Act, which I'll refer to as the IILA, it's a big long name, it controls and restricts the movement of liquor from one province to another, as well as the importation into Canada. And before the most recent amendments to the IILA, which I'll speak about shortly, Section 3 of that Act prohibited the ability of individuals to take wine from one province to another, and the section that prohibits them is on this slide, which I won't go through in any detail. The bottom line is that if you want out-of-province wine, you have to go through the LCBO. And what's interesting about this act is that if you punishment for contravening the act, the first time you'll get a $200 maximum fine, and if you fail to pay that, you could be thrown in jail for a term not exceeding 3 months. If you contravene it a second time, you could be fined anywhere between $200 and $1,000, and if you fail to pay that fine, they could throw you in jail from somewhere between 3 to 6 months. And if you are silly enough to do it more than twice, you could be thrown in jail from somewhere between 5 to 12 months. I'm not aware of anybody being thrown in jail under the IILA. So on June 28th of 2012, Bill C-311 received royal assent and became law. It was a private member's bill put forth by Dan Albus from BC and received unanimous support. And this bill amended the IILA to allow for a personal consumption exemption. And that was found in Section 3 sub 2 sub H, and stated that the original prohibition to importating wine did not apply to, and I'll just read, the importation of wine from a province by an individual if the individual brings the wine or causes it to be brought into another province in quantities and as permitted by the laws of the latter province for his or her personal consumption and not for resale or other commercial use. So bottom line for Ontarians, you can bring BC wine home with you, but Ontario still has a say in how much and in what manner you can do so. There is an argument out there that the IILA limits the free flow of Canadian wine from moving from one province to another, and therefore it is unconstitutional. And people who advocate that position rely on Section 121 of our Constitution, Act 1867, which I'll let you read it, but the bottom line is that all grapes grown, produced, or manufactured by any of the provinces must be admitted freely into each of the other provinces. So back to the decision. So this argument that the IILA was unconstitutional was precisely the argument that the Wine Club put forward as soon as the LCBO mentioned the IILA. And because the IILA requires that all liquor entering into Ontario be sold to the LCBO, a finding that this legislation is unconstitutional would no doubt change the liquor laws across this province. It would have significant impact, and some observers were even saying that this may be the end of the LCBO, and everybody is looking at this decision with interest. I'm not quite sure if that would have been the result, but it's certainly one of interest for the legal minds and for consumers as well. So this matter was heard before the Divisional Court this past fall, and a decision was released at the beginning of November. And the Divisional Court found that the process followed by the IPC breached the duty of fairness to the LCBO, and that the LCBO was not afforded a fair opportunity to be heard on the matter of remedy, and in particular, the remedy being the order of the Commissioner to cease collection of personal information and destroy it. So consequently, the court ordered that the matter be remitted back to the IPC for reconsideration. There hasn't been a decision since that time, but I can tell you when the decision came out, I was keenly looking through the decision to see, well, what happens with this constitutional question? It's a big question, but alas, no mention of the constitutional question. So it will be interesting to see what the IPC does at the end of the day, what the findings will be once she reconsiders the matter. But everybody should be afforded natural justice, and matters should be fairly adjudicated. And in this case, the LCBO wasn't afforded that opportunity, so the court is making the IPC do it again, do it properly. In sending the matter back to the IPC, the court offered some very interesting observations and comments. It stated that it was unclear as to whether the IPC made a consistent finding on the issue of whether the LCBO's customer was the club or the club member, and that's significant. Both the LCBO and the wine club submitted that the wine club member, not the wine club themselves, were the LCBO customer. But the LCBO's argument in this regard is premised on the assumption that its customers must be identifiable for it to be able to discharge its statutory duties and responsibilities under the Liquor Control Act and the Liquor License Act if it is required to sell alcohol to anonymous or fictitious individuals. The board also said that the club members can only be LCBO customers if they are identifiable. Without that identification, the wine club, I guess, becomes its customer. The court makes mention, it's interesting, the court makes mention of the fact that the IPC has found that the LCBO is permitted to obtain personal information from club members who attend personally to pick up their product, and that the LCBO in that case isn't required to destroy the personal information it obtains through that mechanism. So the court asked the question, if club members are purchasing the product from the LCBO in both instances, picking them up itself or getting it through the wine club, what logical reason is there to distinguish them on the basis of where they pick up the product? So I think it's a good question. I think that the IPC will take the court's direction to heart, and hopefully we'll have some clarity on the issue from the IPC. So moving along to coming back to the IILA and what does it mean? What is it meant for Ontario? How does the amendments to the IILA affect us? So unfortunately, not much has changed for Ontario consumers thus far, especially if we like our BC wine, we like our wine from other provinces. The laws still require the provinces to weigh in on how wine for personal consumption will be implemented. The In Ontario, the LCBO has issued a policy statement regarding the personal consumption exemption, and it states that Ontarians can bring only 9 liters of wine on their person from other provinces, and it strictly prohibits the ordering of wine online from other provinces. This, as I mentioned, is a policy statement, and so far there's no piece of legislation that really speaks to this issue, and some argue that because it's a policy statement, it's not law. So there's nothing at this point prohibiting Ontarians from purchasing out-of-province wine. But consequently, if one relies on what the LCBO is saying, an Ontario resident wanting to buy wine from BC, for example, would have to go through the LCBO's private ordering department, and that's what we do anyways with respect to foreign wine. If we want to get French wine that isn't normally on the LCBO shelves, we go through the private ordering program. The LCBO is saying, right now that's what we need to do if we want, say, for instance, BC wine. But we do have some good news on the horizon relating to the Ontario laws, and this past September, Bill 98 was introduced as a private member's bill by MPP Rob Milligan of Northumberland Quinte West. That bill has passed second reading and is currently before the Standing Committee on Government Agencies, and it amends Ontario's Liquor Control Act to add the following provision, which interestingly removes the LCBO's powers as it relates to the importation of wine for personal consumption. And you'll see, as it states, an individual who is 19 years of age or older may import or cause to be imported wine into Ontario from another province if the wine is for his or her personal consumption and not for resale or other commercial use. And interestingly, sub 2 is the board's power under this act, being the Liquor Control Act, do not apply to wine imported by an individual in accordance with subsection 1. So other provinces have made it easier, a little bit easier, for their residents to purchase out of province wine as a result of this personal consumption exemption. And in British Columbia, as you'll see noted, individuals are allowed to have unlimited quantities of Canadian wine shipped to them. In Manitoba, individuals are able to have Canadian wine shipped to them that has been legally purchased or acquired in any part of Canada other than Manitoba. And Nova Scotia, while we're still awaiting some changes, they've indicated that they will permit the direct-to-consumer shipping, so we're waiting to see what happens on that front. And I think these are all very positive changes. Everything is progress. So since the last time I was here a couple of years ago, none of these, I think perhaps the Bill C-311 was proposed, but it's been a while, so all good changes. So changes in customer and industry attitudes result in changes in the law. And we still have a long way to go, but look how far we've come just in a few years. Canadian wineries are getting better. We're getting more recognition domestically and abroad. Unfortunately, for whatever reason, Canadians are terrible at recognizing their own talent, and they need people from abroad to kind of say, you know what, you've actually got some good stuff. And I think there's some momentum there. There's a growing trend in wine tourism. Niagara is one great example. Prince Edward County, where I live, is a burgeoning wine region. The industry really relies on tourism in the high season for its business. I'm giving these shameless plugs for Prince Edward County. You got to come to Prince Edward County. In Prince Edward County, there's well over 30 wineries. It's growing in numbers. And we have some new areas, some new growing wine regions, such as South Coast, which I understand is Simcoe and Port Dover area, Stouffville, and Southern Georgian Bay, for example. We also have some new products, like I mentioned, new varietals, like the white port, for instance, using Frontenac grapes, so that's all good. We're also seeing some customer outrage. We're looking at these antiquated laws. They are old. It's when they all came down when the Prohibition era was in place. And there's some grassroots support for change. We have the Free My Grapes initiative, great initiative, as the impetus for change. I think they had a very big role in Bill C-311. So it just shows how influential consumers and the public are in this regard. I also make mention of the Great Canadian Wine Challenge. It's interesting, after the first anniversary of Bill C-311 this past year in June, a group of wine lovers through Twitter have undertaken to drink nothing but Canadian wine for a year, and I'm one of them. And many participate, and I'm not sure if you know about this, but there's an Ontario Wine Chat on Twitter on Wednesday nights, and what follows is the BC Wine Chat, and I can barely stay awake for the Ontario Wine Chat, but it really gives you a flavor about what the industry is facing, the struggles that they face legally or otherwise, what consumers are frustrated about, what consumers like. So it's an interesting mechanism. Social media is a really neat platform for people to express their views, and again, a platform for change. What's also great to see is government support. Politicians are drinkers of Canadian wine as well, and are becoming more aware of the challenges that the industry faces. And so we are seeing, again, more positive change. Bill C-311, of course, is a prime example. We'll see what happens with Bill 98. We hope that will be passed. So we have Premier Wyn's wine and grape strategy, and this allows VQA wines to be sold at farmers markets. This is a great change. I'm not aware of any of the details about how that's going to play out on the regulatory front or otherwise, so that will be interesting to see. But very good change. We have more money injected into the support of local wineries to help the sector grow, $75 million, not too shabby. The strategy is also setting up an Ontario Wine Fund to support winery and vineyard investment for specialized equipment and machinery, and also to enhance marketing for the province's wines, not only locally but globally. It also talks about setting up a wine secretariat, which I understand is intended to be a one-stop shop for discussions to take place between the province and industry in an effort to reduce red tape for the industry, help grape growers and wineries become more competitive, which will, lessening the red tape for these wineries will be more than welcome. So I view these changes to be very positive, and I look forward to seeing what flows from them. So I thought, I've got some time, but I thought I would end on a happy note. Not that to say that anything I said was unhappy, but I came across this piece of legislation that I had no knowledge about, which I wanted to share with you, and perhaps you've heard of it. It's the Ontario Wine Week Act 2005, and it's very short. It's one page long, and I say warm and fuzzy statements about Ontario wines, and I'm not. I'm trying to be funny just because it is actually a very nice statement, and I thought I would share that with you as an ending to my presentation. It has this preamble which talks about the wine industry, and at the bottom line, what it does is proclaim that the third week in June of each year is proclaimed as Ontario Wine Week. But I thought you would find this of interest, the preamble. Beyond any doubt, Ontario has established itself as one of the world's great wine regions. Over the past 15 years, no other industry in Ontario has progressed so quickly and made such a dramatic impact on the international stage as the Ontario wine industry. Ontario ice wine is now a global icon wine. Together, the grape and wine industry have an enormous effect on the province's economy. Every litre of Ontario wine sold in the province adds $3.88 in value to the Ontario economy, compared to 46 cents for every litre of imported wine. This act recognizes the efforts of Ontario grape growers and winemakers by designating the third week in June as Ontario Wine Week, a week to celebrate the wines of Ontario's 4 wine regions, the Niagara Peninsula, Pelee Island, Lake Erie North Shore, and Prince Edward County. This week is significant because June 16, 2005 will mark the 10th anniversary of the Ontario Wine Competition and is the day that consumers can taste and celebrate the best VQA wines that Ontario has to offer. Therefore, Her Majesty, by and with the advice and consent of the Legislative Assembly of the Province of Ontario, enacts as follows, and there you have it. So I thought I would add on that happy note. Thanks very much for having me.
So we've got some time for questions before Alexandra has to quickly catch a bus.
Train, yep.
Back to Prince Edward County. So please, open up the floor. Any questions?
Yeah.
There were some recommendations to BC legislation that were suggested last week. Two in particular that I thought were interesting was allowing wineries to establish off-site tasting rooms, as well as selling other wineries wine in their own tasting rooms. And I just wanted to know if you could comment on some of the legal challenges that Ontario would have to overcome to have similar practices in place here.
Yeah, one of the major challenges for all of the wineries, to be honest, and not just Ontario, is market access. And so it would obviously increase market access for Ontario wineries to have private wine stores or sell other people's other wineries wine. I think it would be a great initiative. Currently there are some barriers. There's some trade issues relating to that. Certain licenses have been granted to some wineries, not to others. In order for that to happen, there needs to be an overhaul of some of the laws, trade laws in particular. The European Union, for instance, may have something to say about that. If it was to give a leg up to domestic wine, it wouldn't go over all that well. So it needs a conversation to be had. I think the time to have it is now because the industry is growing. I think it would be a great thing for Ontario wine, but it's not a simple answer. So.
Any other questions?
Yeah.
Alexandra, what sort of time frame on that Bill 98, the provincial one?
It was introduced in September and went through first reading. There was a debate at the end of September, and then it passed second reading. It's before the standing committee, and when I looked at the website just recently to see if there's any agenda or hearings or stuff, I don't know yet. Hopefully that will go through, but I suspect that industry will want to have to go before the standing committees and have a say in all of it. So I think, again, a great opportunity for industry to be involved and to weigh in, or consumer groups to weigh in and be involved. So.
Well, I can't wait till you come back and give us another update. Usually our speakers speak every other year, so in 2 years' time we'll be able to see the progress that we've been making. But I'd like to give you just a small token of our appreciation for
Thank you very much.
Your trip today.
Thank you very much.
And also just a reminder to the rest of you, our next lecture is Monday, February 24th. So we don't have a lecture next week, it's Family Day. But then Linda Bramble is going to be joining us. She's a COVI professional affiliate, and she will be talking about the influence of wine writers on consumer behavior. So she's such an excellent speaker, so I'm really looking forward to hearing an update from her. And thank you to our online attendees today, and just a reminder that the videos will be posted approximately 1 week after they've been recorded. So you can go to the COVI website and also download and look at the material at your leisure, or maybe for the students in the crowd for preparing for some assignment or project that you're doing. So thank you, Alexandra.
Okay, thank you. Thank you for having me.